Now, for the sake of simplicity, we are classifying parliamentary privileges into two, one which are going to be enjoyed by the members individually, and one the other kind which belong to the House collectively. So, firstly we will discuss parliamentary privileges which belong to members individually, starting from freedom of speech. The very essence of democracy is the exchange of free and fearless opinions. The members of the Houses of Parliament exchange their views, opinions and ideas inside the houses without any favor or fear from any case with regard to like defamation, etc. They are fearlessly exchanging their views. Article 105, Clause 1 safeguards freedom of speech or expression of parliamentarians, and Clause 2 says that there would be no criminal or civil liability against anything said or any vote given inside the Houses of Parliament. The immunity is not available only for the spoken words, but also as specifically mentioned under Clause 2 of Article 105 or 194, that for any vote given inside the Houses of Parliament would also be immune. In the case of Tej Kiran Jain versus Sanjeeva Reddy, it was held that when it is proved that houses are in session and the proceedings of the Parliament are going on, anything said within the Houses of Parliament is immune. This anything is of widest import and it can be interpreted as if you can say each and everything, whether relevant or irrelevant, inside the Houses of Parliament. But as per the rules of procedure, it is also required that you can't use unparliamentary language, or the conduct should also not be unparliamentary. So, all the proceedings of the Parliament has to be regulated with the help of rules of procedure as well as standing orders with regard to regulation of proceedings of the Houses, which includes Articles 107 and 121, wherein you cannot discuss the conduct of either Supreme Court judges or High Court judges. That is also barred within the Houses. Privileges given under Article 105 and 194 are different from freedom of speech and expression granted under Article 19(1)(a) of the Indian Constitution. 19(1)(a) grants freedom of speech and expression which can be restricted with the help of Clause 2 of Article 19, that is, there can be grounds available to restrict that freedom, and therefore that freedom is not absolute. But whereas the freedom or the privilege granted to parliamentarians is absolute, it does not carry any limitation or restriction when they are within the Houses of Parliament. But when they are outside, they cannot defame, they cannot utter a single word which can be said to be defamatory or causing any ill will or causing any harm to anybody. Similarly, when they are going to be within the Houses of Parliament, they are having full right to attend the sessions of the Houses of Parliament. They can't be detained without a valid order. But if there is a valid order, they are similarly as an ordinary citizen of India can be detained by the courts on some pretext, on some charges or on some cause. In P.V. Narasimha Rao versus State, the Supreme Court of India in this very famous Jharkhand Mukti Morcha bribery case got an opportunity to see and analyze the interpretation of Article 105 clauses 1 and 2, whereby they held that even the bribes givers who gave bribe for asking the questions within the House of Parliament, they are immune from any kind of proceedings against them. even the bribe takers, they were also immune from the proceedings of the House because of the words given under 105 clause 2 that they can say anything or they can also vote within the houses of the parliament. So, the court held that bribe takers who took bribe, who took money, but they cast vote, they have got full protection covered under the articles provided under the Constitution of India, but the bribe takers who have not voted within the houses of parliament, they are not immune, they can't be given protection too. Whereas Lok Sabha can take action for any person, whether bribe takers or bribe givers, whether they participated during the proceedings of the houses or not, but Lok Sabha can take action against any erring member of the house. Then we come to right of publication of proceedings of the houses. Publication of the proceedings of the houses can be there only by or under the authority of the houses. No paper, no report, vote or proceedings of the houses can be published without the authority of the house. Common law accords qualified privilege, which means that there can be fair and accurate reporting of the proceedings of the house. In Wasson versus Walter, Justice Cockburn also said that it's a national and public importance to give fair and accurate proceedings report to public, which has a deepest interest in knowing what is going on in the parliamentary houses. In 1956, Parliamentary Proceedings Protection of Publication Act was also enacted, but in 1975 this was repealed. Later on, with the help of Constitution 44th Amendment Act 1978, Article 361A incorporated this publication right, which says that no person would be liable on the basis of civil or criminal liability if he is reporting the proceedings of the houses which are substantially true and the proceedings have been published without malice. So, if the proceedings are without malice, they are fair and they are accurate, substantially true, there would be total immunity, total protection under the constitutional provisions. There can be no arrest or imprisonment of parliamentarians 40 days prior to the session of the House and also 40 days after the session is over. This has been provided under section 135A of Code of Civil Procedure 1908. So, there can be no detention or imprisonment of a legislator. If he is being detained, he has to be released so that he can attend the sessions. As per the rules of procedure, rule number 261 says that the detaining authority has to tell the chair of the House regarding the reasons for the arrest or imprisonment made, also where the person has been detained and also the time of detention and also for how much period he is going to be detained. So, with regard to all these things, the arrest or imprisonment is the issue on which parliamentarians have total protection. It has been held in the case of K. Anandan Navyar versus Chief Secretary, Governor of Madras, that there is no difference between an ordinary citizen and parliamentarian when there is a valid order of detention against any of them. With regard to right to exclude strangers, this has been provided within the parliamentary privileges that the chair of the House is having all powers to exclude strangers as well as non-members of the House. The object is that they may intimidate the members of the parliament or they may interfere during the proceedings of the houses of the parliament. So, there can be orders of withdrawal against the strangers or the non-members when the houses are in session, especially when the secret sittings of the houses are there. There cannot be any non-member or a stranger allowed except with the permission of the chair of that particular house. Exceptions may be Council of State members or other members with the permission of the house can be there.